Thank you, Mr. Chairman, Madam Vice Chairman, dear colleagues on the Judicial Proceedings Committee. I had my staff distribute to you a copy of an article that was in the Washington Post, headline, "Sex Offense Law in Maryland Said to Have Major Flaw." And this article describes well the source of this legislation. It talks about two very similar cases. One taking place at Glen Burnie High School in Anne Arundel County, where a 30-year-old English teacher, a full-time English teacher at the school, had sex with a student and then was sentenced to prison for 7 years and was convicted of a felony under it. Meantime, in Montgomery County, the Post tells the story of Scott Spear, who was 47 years old and a full-time teacher at Julius West Middle School, which I think is in Senator Forhan's district, and yet he was a part-time coach, track coach at Richard Montgomery High School in Rockville. And his MO, as far as we can tell, was to get to know girls in his capacity as a full-time teacher at the Julius West School, and then follow them to high school, essentially, in his capacity as a track coach. And in that context, he would get to know them, and then exploit this amazing, remarkable loophole in our law, which I hope we're going to close with this legislation, by befriending her, romancing her, and having sex with her on the weekend. Now, if he'd had sex with her at school, if he'd had sex with her during the school hours, that would have been punishable under our existing law. But he took advantage of what's called the Saturday afternoon loophole under our laws. He basically tracked his prey through middle school and high school, and then this 47-year-old was able to have his way with the 16-year-old girl whose name we don't know. He didn't commit a crime. He is on paid administrative leave from the school. Both the high school and the middle school were notified of the fact that there had been sexual contact between a coach and a 16-year-old girl. Now, the legislation might be familiar to you. Over the last few years, we've been struggling to get the language right. I hope that we've got it right, or if we don't have it right exactly now, we will have it right by the time we get through the voting session on it. Essentially, it states that a person who's 21 years or older who holds a role of authority at any public or private school at the preschool, elementary, or secondary school level, or in any sports or recreational facility, or as a volunteer or supervisor under any of these facilities or programs, may not have sex with a minor. And then this is in deference to colleagues last year who were worried that you might have a guy who graduated a couple years ago, comes back, and then falls in love with a girl a couple years younger than him who he knew before. We've said if there's a 7-year gap between them, and we think we're giving there ample, generous distance, if there's a 7-year gap there, this person in a position of authority is guilty of a crime. And so we'd be able to close this egregious loophole and a bunch of cases around the state. It's not just in Montgomery County where this has been a problem. There have been cases in Anne Arundel, in Howard. The Washington Post discusses several of the other ones where this part-time employee, person in authority, part-time coach or substitute loophole has been exploited by sexual predators. So let's protect our kids, and with that I submit it to the wisdom of the committee.
Senator Jacobs has a question.
How did you come up on the 7 years? I mean, aren't we going to be letting a lot of people go free who abuse our children?
Well, you will recall, I think, Senator, we went through this last year, and for me, it is something of a pill to swallow to put that in there, because I was not on that side of it. Some of our colleagues felt that you wouldn't want a situation where you had, say a guy who graduated from the high school, he was on the basketball team, he comes back 2 or 3 years later to coach the girls' basketball team, and you've got a Romeo and Juliet situation with a girl who's 3 years his junior. He shouldn't be doing it, the argument goes, but he's 20, she's 16. Do we really want to make this a crime? So I think that we looked at the various laws of statutory rape, which are complicated. It's a little bit like Swiss cheese, and this is one of the holes. But 7 years seems to be a distance that sufficiently encompasses the possibility
but what
of
about
anything.
5 years? 5 years is pretty far apart. I mean,
Well,
a 20-year-old with a 15-year-old?
Yeah, I mean, and I think when we get into the voting session, I think that we are going to have to bite the bullet on that, and that would be amenable to me. I think what we've taken here is the colleagues who agreed that part-time employees or full-time employees who are not permanent employees, who presently also escape application of the law, should not be getting away with this in general. But there are some colleagues who felt that you don't want to draw it so broadly that we're criminalizing something that most people would recognize as basically innocent. So I tried to bend over backwards to say, let's create a very big buffer zone there, 7 years. There are very few people, who would say, like in a case like this, the guy who went to jail for 7 years, he was 30 years old, his victim was 17. Or, in the case in Montgomery County I discussed, Scott Spear, 47 years old, his victim, 16 years old. There were, hundreds of text messages going back and forth in these cases. So it's very clear what's happening there.
Thank you.
Okay. Thank you very much.
Thank you, Mr. Chairman.
Let's hear from Melissa Rock.
Good afternoon, Chairman, Vice Chair, and members of the committee. Thank you very much for the opportunity to testify today. My name is Melissa Rock. I'm the Child Welfare Director at Advocates for Children and Youth. We are an independent nonprofit organization that focuses on doing public policy work on behalf of children across the state of Maryland. I am here in support of Senate Bill 460. This is an important bill to help close some of the gaps in our laws that are there to protect children from sex abuse. I think the important thing to think about with this bill is that the role of the person who is in a position of authority, it's the child's perspective that matters. It's how the child sees that person and that dynamic of authority that ends up compromising the child. And I think few young people would have a sense of whether or not that adult is part-time, contract, versus full-time and an employee. And so I think it's really important that we eliminate this distinction in order to better protect Maryland's children. So I would just urge a favorable report on Senate Bill 460. Thank you.
Thank you. Let's hear from Lisa Jordan.
Good afternoon, Mr. Chairman, Madam Vice Chair. I'm Lisa Jordan here on behalf of the Maryland Coalition Against Sexual Assault and the Maryland Children's Alliance, both in support of Senate Bill 460. I want to say thank you to Senator Raskin for introducing the bill and to many of the other senators who've worked on this issue over the years. Before I say anything else, Senator Jacobs, we don't need a law to cover the 15 and 20-year-old. That's already covered by statutory rape laws. The gap is really for 16 and 17-year-olds. So certainly those children are covered is the 16 and 17-year-olds who are left without protection right now. The concern of MCASA and MCA is sexual exploitation by persons in authority. We are not trying to raise the age of consent. We are not trying to criminalize true love. We're talking about people who have authority over teenagers and are using that authority to exploit the teenagers. Senator Raskin and my colleague Ms. Rock have already talked about eliminating some of the current distinctions that really don't make any sense that this law would eliminate. A couple of other things to think about is that this bill would allow a 5-year penalty, up to 5 years. It would encompass persons in authority who work with children only at the place they work. So it's not like just because you're a teacher you can't have sex with children. We're talking about at the place you work. The person in authority would have to know that the person was a student or know that the person was someone participating at the sports and recs facility. And it would have to, for the sports and recreational facilities, these are facilities and programs. They are not pickup games on the corner. They're actual programs. The last thing I just wanted to comment on was the 7-year age gap. It's really only 2 years more than we have right now. because right now, if you have a 16-year-old, the person in authority has to be 21. That's a 5-year age gap. And if it's a 17-year-old, there has to be a 4-year age gap. So 7 years is not a huge amount more, but it is designed to try to provide some comfort to people who are concerned about people who are close in age. And I've been working on this bill since Senator Raskin was a delegate. Neither one of us had any gray hair at that point. Or Senator Zirkin. And Senator Zirkin was a delegate. And I mean, since I've got files since at least 2003. And, it's an issue that needs to be fixed. I've now had young women in my office who have been sexually abused by persons in authority in their 30s and 40s. And if we would have fixed the law back in 2003, 2006, all those many other times, those teenagers would have been protected. So I don't know what the perfect number is. I don't know if it's 7 years age gap. I don't know if it's 6 years. But I really urge the committee to find something that works, to look at the compromises in this bill, and pass something to protect teenagers.
Okay. Thank you very much. Senator Zirkin has
Just
a
a quick
question.
one. I mean, part of the problem with, as we've gone through this over the years, is the incremental climbing, and I understand what you're trying to get at, but I mean, the details in the bill, I mean, you're not trying to get to, for instance, a 17-year-old, because in here, a 17-year-old who prior to this was in a rec center playing basketball, and somebody who was a coach there, and now is in college, and happens to, know this person from back home. I mean, you could literally be criminalizing a relationship between a 24, 25-year-old at a rec center, it says here, was previously enrolled or participating in the institution or program. So somebody who, when they were younger, was playing basketball and knew some 21-year-old coach, now they're in college and the person's older, and a 24-year-old and a 17-year-old, I mean, you don't think that that's a criminal thing, but the problem is that the language of the bill says it is.
Yes, the language of the bill does say that it is, and of course, as soon as that person turned 18, it would no longer be a crime. And what I would say, Senator, is that as public policymakers, you have to draw the line somewhere. And right now, what we're doing is, instead of saying to the persons in authority, wait until that person turns 18, we're saying, all right, we're just going to let the teenagers be exploited.
Look, I have
are there
girls. I don't want. I mean,
yeah.
You can make it 20. You can make it 50 for all I care. But I mean, at the end of the day, but it's like you're criminalizing activity. The problem is that when you say you draw the line somewhere, you are drawing the line in this bill and others. And this isn't if somebody. Would you agree? And maybe I'm just reading it wrong. Tell me if I'm reading this wrong. This isn't somebody who's even in the position of authority at that point in time. Somebody who later in life runs into the person who happened to have worked somewhere before. Now they're 7 years apart. They're not even in that position of authority anymore, and their relationship is criminal. Am I reading that right?
I'm not sure I'm completely following your hypothetical.
Let's just say you have a 17-year-old
yes.
who used to be a player in a rec center, and at the time she was young, and he had an 18, 19, 20-year-old coach, whatever. Then later on in life, she's in college now. She comes back to town and runs into the guy who is now 24. So they run into each other at a
well,
whatever,
but if she were 17 and he was 18 or 19,
she's 17 and he's 24.
She's 17 and he's 24 when she's in the program. Yes, this bill
it says here,
would address
somebody
that.
was previously enrolled or participating in the program. It's not even somebody who's in the program now. It's somebody. So the 17-year-old used to be involved in the program when the guy was working there. Now,
while the person in authority was there,
and now
yes.
they run into each other. She's a first year in college. She has a date with a guy who used to be there. That's now a crime,
yes.
even though it's legal. Because they used to be in that situation together. Now, like what is now legal activity that nobody looks askance at, because they used to have something in a rec program. They used to be in the same rec program together. Now it's a criminal offense?
No, I think that's mischaracterizing it to say that they used to be in the same rec program together. It would have to be something where that 20...
because they used to have something in a rec program. They used to be in the same rec program together. Now it's a criminal offense?
No, I think that's mischaracterizing it to say that they used to be in the same rec program together. It would have to be something where that 24-year-old had authority and could have exploited the authority. So it's not a situation where it's a janitor, it's a development person, or all of that. And again, Senator Zirkin, right now, all of the risk is on the teenagers. Now, if you want to say that, there's something that we want to tinker with when a person in authority leaves, but the concern is, and what that's designed to address, is persons in authority who, kind of groom the kids while they're there and then leave to be with them. Honestly, it's a 17-year-old. The 24-year-old is an adult. They could wait. They could wait. There's got to be a full 7-year age difference.
Person of authority, when we first did this, which was years ago, I thought the whole concept of this was somebody's exerting this will, that they're overriding the will of, because 16, 17-year-olds are permitted to have sex. Like, that is not illegal. So,
right. And we're not trying to make it illegal.
Excuse me? So at the end of the day, this is somebody, so we're turning this into a crime. But this isn't even somebody who's in the position of authority at that time. I mean, this has gone beyond to say that they used to be in a position where it could have been in a position of authority. Now, years down the road, where they're still exerting this will over the person, and it's still a crime.
Well, it's not years down the road in your hypothetical.
Could be. I mean, there's an 17-year-old coach, and in a young kids rec league, and 17-year-old coach, 10-year-old, coaching 10-year-old girls, and then all of a sudden, the 10-year-old is a first-year college student. They run into each other, and they happen to have been in the same place. Now it's a crime.
Yeah, I'm not denying that they're difficult issues. I'm not denying that it's difficult to balance. There are two provisions in the bill. One is when the person is actually a person in authority at the school at that time, and it sounds like, I'm hoping, that you don't have concerns about that.
No.
The provision that you're talking about is when you have someone who used to be a person in authority and now has left, and the policy issue that I would urge this committee to address and to solve is, how do we have those people be prevented from kind of grooming kids and then going after them later? And if this language doesn't work, let's find language that does. But leaving it the way it is right now it's really abandoning your responsibility to protect teens, because listen to the stories that Senator Raskin is presenting. Listen to the clients that I've talked to sitting in my office saying, this guy was 30, 40 years old, and we're doing nothing to protect those kids. So I am happy to work with you to try to find something that's reasonable and sensitive. And again, I'm not trying to criminalize true love. If we have hypotheticals that are going to make this so it's inappropriate, let's find language that works, and please try to pass a bill.
Okay. Thank you very much. Let's hear from Farrah Smith.
Good afternoon. My name is Farrah Smith, and I work for Life Crisis Center. I'm a licensed clinical therapist, and I have been working in the area of child protection in one form or another for the past 18 years. For the past 8 years, though, I have been at Life Crisis Center and working with over 1,000 children and families in the area of providing trauma-specific treatment to the victims as well as their families, educating the court and the community about trauma effects on children. In the past 5 years alone within Wicomico County, as part of my job, I sit on the multidisciplinary teams for Worcester, Wicomico, and Somerset counties. So I hear about the cases that come in that may not go to prosecution. So in the past 5 years alone within Wicomico County, we've had coaches for high school volleyball, football, weightlifting, soccer, a choir director, and several substitute teachers who have been alleged to have offended children in our community. All but one of those alleged were over the age of 30. So we're not talking about those kind of cases necessarily that we're seeing most of the time. These cases devastate the community and violate the trust that is granted the individuals by their position alone. The children work to overcome their traumas that sometimes extend into a lifetime of poor relationships, substance use, periods of suicidality. I'm often working to help correct thinking errors, body image problems, sexual identity issues, and advocating for victims in the community to help others understand the dynamics of abuse and the effects of trauma. In one of our most recent cases, which is now in its third retry because of hung jury issues surrounding this exact thing, where he was a part-time coach for the football program. The victim at the time, who is now an adult, described his football coach in court as a role model who he emulated and wanted to be proud of him. When his abuse began at age 16, he didn't tell because he himself could not reconcile in his own mind how this person who he had looked up to, who had helped him academically, who had helped increase his performance, allowed him to perform at a level where he was able to get scholarship opportunities in the football program, could also take advantage of his body in a sexual way. He blamed himself, and as a teen thought that he should be able to handle it. So the other issue that we have with these older kids is that there is an issue with telling, but also they feel like they should be able to deal with things, and they're not adults. And so as adults that are around him, when we find out about things, it makes it very difficult when we have that. He blamed himself. He had a really hard time. He didn't tell initially. He ended up moving out of the town. He partied and ran into all kinds of problems, became suicidal, very depressed. After moving out of state, he felt like he had put it behind him, and then came a knock on the door one day. And the police were investigating another victim, and he felt like he had to tell. He started having flashbacks and nightmares, and after a lot of consideration, he told his story to the police. And so it just became a really big problem. So I see a lot of the older teens who really blame themselves. They take on a lot of that, and causes a problem.
Senator Raskin has a question.
Thank you so much for your testimony. How many cases like this have you seen where students were the victims of the sexual romantic attention of a teacher, coach, someone else in a position of authority? In terms of me treating them directly, or just cases coming through the advocacy center? I would say between the 3 counties, maybe 20. Okay, and how would you characterize generally what the emotional, psychological, and intellectual effects are on kids in this situation? A lot of issues around sexual identity, especially if it's a male coach and a male victim. That's like the case you were talking about with the football. Yes, yes. However, we have had, I had a young girl who was victimized by a soccer coach. A lot of trusting issues with positions of authority. It just creates a different dynamic. You also have this public thing that happens where things go out into the press. Sometimes it's not very veiled who the victim is, and they're persecuted in their schools. I've had kids that had to change school districts, move out of the area just because they were being harassed. It creates another level of their victimization. Are you aware of any cases where it's been good for the kid, where it's been a positive relationship, where you've seen positive things come out of it? Not personally. Okay, thanks.
Senator Zirkin.
Of those 20 cases, how many of them weren't covered under the existing law? I'm trying to understand the scope. How many of the cases you were just referencing were covered? It sounded like some of them were coaches, which I think is already covered. So what? Well,
the part of the issue is, so for example, in this case that was being handled, there was implied consent. So the family saw him as the coach. He saw his coach as the coach, whether he was on the playing field or not. And so then the issue became, when the prosecution went to trial was where incidents happened, and so, well, we can't count this one because it happened at the house, and so he wasn't technically the coach. And so the issue became that, and that's what I've seen in several of the cases where kids are, sometimes they are offended at the school, and that would be something different. But we've had several cases. We had a female with the volleyball coach. He took a plea in that was a similar kind of an issue for the prosecution of trying to make sure where things were and the timing of things in the coaching capacity and establishing that relationship, because there's a piece in things about having care and custody of the minor child.
I mean, I'd be interested to hear about that case, because I mean, in the law, I mean, it doesn't say that the act has to take place at the place of employment. I mean, there's nothing in here. It just says that the act occurs, and the person was a minor at the time, and the student was enrolled at the school where the person of authority was employed. It doesn't say anything about where.
Well, I think that's the issue, is if the authority was applied, and so I think that the defense is often that, well, there was no authority here because we weren't talking about the playing field. This was an outside relationship, kind of like implying that there is this kind of Romeo and Juliet thing, even though the guy's in his 40s. So I think that, there's kind of a twisting that happens, especially with teenagers, because there's kind of this look at that, well, they had a car, they could have gotten away, why did they stay in? And there's, especially in the sporting arena, there's a lot that goes into those relationships, like kids' scholarships are on the line, their next career move, or scholastic aptitude things are kind of on the line with that. They get a lot of special privileges as being kind of the favorite. So it's a really difficult situation for the victims a lot of times.
Thank you.
Senator Raskin.
This legislation would take this to being a 24/7 rule. That is, if you've got authority and power over a kid in one of these institutional settings, then you're responsible whether you're on the field or off the field, whether it's a weekday or a weekend, right? What do you think about that? Is it possible to have a relationship of equals between a 16-year-old or 17-year-old and a 40-year-old on the weekend?
I think that part of the issue is exactly what has been testified to already, that it's about perception, and the families and the kids look at them as, that's my coach. When they introduce them, that's my coach. And so to have that dual relationship becomes very troublesome.
And would you say that most of these relationships, they do whatever they can to keep it as clandestine and as secret as possible, so it's very hard to say that they have any relationship other than coach-student or teacher-student, right?
Yes.
And finally, are there any differences in the emotional and psychological effects on kids who are put into one of these situations based on whether the teacher is a full-time teacher or a part-time teacher or a permanent teacher or a substitute or a temporary teacher?
I'm not sure that the kids, to my knowledge, have ever known about what the status of whether they were full-time, part-time, or anything else.
Okay, thank you.
All right. Thank you very much. Skylar Morgan.
Good afternoon, Chairman, Vice Chair, committee members. My name is Skylar Morgan. I'm currently the intern at the Economic Matters Committee. I'm here today in support of Bill 460. I would like to look at Section 5106Z of the Criminal Procedure Government State Article, which gives a 3-year statute limitation. The Maryland Coalition Against Sexual Assault reports that 1 out of 5 children is sexually assaulted, which would mean in Maryland about 327,000 are assaulted. A 2000 national study showed that 75% of children take over a month to tell somebody about their experience, and 50% take over 5 years. Due to that information, I wanted to propose that the 3-year statute be raised to at least 5 years to give children more time to come to terms with what they've been through, and also hopefully help them gain strength to actually tell somebody so that they can come to justice with their situation. That's all.
All right. Thank you very much. Let's hear from William Katzeff.
Frost, ladies and gentlemen of the committee, my name is Stephen Colm, the State's Attorney Coordinator and Executive Director of the State. Chairman Frost, ladies and gentlemen of the committee, my name is Stephen Colm, the State's Attorney Coordinator and Executive Director of the State's Attorneys Association. We are in favor of this bill with one exception, and that is the questions that have come up before about the age difference. We are in favor of 4 and 5 years old and not 7 years old, and other than that, we would strongly support this bill. Thank you very much.
Okay, Mr. Katzev?
Summarizes my comments.
Okay. In that case, let's hear from the opposition, Ricardo Flores.
Good afternoon, Chairman, members of the committee. Ricardo Flores with the Office of the Public Defender. I think the issue is complicated enough that I'd like to start by clarifying what this is not about. This is not about non-consensual sex. This is only about consensual sex. This is not about persons under 16. 15, 14, and younger aged people are already covered by our sex offense and rape laws. What this is about is an attempt to codify the type and degree of circumstances that would override otherwise consensual sex, that would override in every single case, categorically, the fact that a 16 and 17-year-old, typically female, agreed to have sex with typically an older male. And that's part of, I think, the difficulty and the controversy around this. The facts are always, in this particular provision, about a 16 or 17-year-old who has agreed to have sex with the other person. The other thing that I'd like to mention in response to what you've been told by the proponents in terms of avoiding the responsibility to cover these cases, there hasn't been a case described that I don't think would be covered under our current 3-602, which is the crime of sexual exploitation and molestation of a minor. There's no age limits there. It doesn't matter who's what age. There's no place or temporal limits in terms of where it happens. As long as the person, any person, has some temporal custody, control, or supervision of another, the minor, they can be held criminally culpable. And it's a felony with a significant sentence attached to it. And so I think keeping those things in mind about where our law is, I think is really important to focus on what this particular provision does and ought to do. In terms of our specific critiques of how this is drafted, the first thing we'd like to note, and this was a discussion yesterday in the Judiciary Committee, is the definition that replaces the current law is really sort of a two-part definition. There is subsection A1, which says a person in position of authority means, and then there's subsection A2, which says a person in position of authority includes. One of the, I think, unintended consequences of subsection A1 is that there's really no criteria, there's really no basis for the underlying idea of the exercise, the improper exercise of influence. Because subsection A1 only has as its factors the age of the alleged perpetrator and the fact that they work at the school. That alone could, if someone is prosecuted and falls within that particular definition, be the basis for their criminal culpability in engaging in consensual sex with a 16 or 17-year-old. Now, I think the intent was to have A1 and A2 read together, but the actual legal application of this in a courtroom allows one to be prosecuted only under A1. And in addition to that, and actually I'll not mention this, Senator Zirkin has already talked about the point of previous enrollment, previous sort of participation in programs. We have a major issue with that. The last thing I'd like to say, I know I'm over time, is that the current law has about 5 different factors that go into what I think is the circumstantial evidence showing that the person exercised improper influence. Age difference, the position that they had, and the other things that you can read in the current law. I think those are sufficient in almost all cases, and certainly in connection with 306, 602, to prosecute people who are doing these bad things.
Senator Raskin has a question, followed by Senator Shank.
Thank you, Mr. Chair. Thank you very much for your testimony. Several things. First of all, you said that none of the cases we talked about described situations that couldn't already be covered under the existing law. And yet the prosecutors have testified, and I think that I testified precisely about such a case, the Scott Spear case in Montgomery County, where you had a guy who was a part-time track coach in a high school, had essentially followed a girl that he'd gotten to know from his permanent position as a middle school social studies teacher to the high school, and then engaged in a sexual relationship with her. And completely escaped the law because he was not a permanent full-time employee of the high school. So,
right, but the law currently has 3-602, which defines sexual abuse as an act that involves sexual molestation or exploitation of a minor.
She was not a minor.
She was. The definition of minor in 3602 is anyone under 18. So she was 16 at the time, as I understand that case. And she would have been a minor under this provision, whether physical injuries are sustained or not. And the other provisions that would apply, I think, apply to the fact scenario that we understood in that case. I've only read probably as much as you have in the paper about that case.
All right, I'll check the facts on it, but my understanding is you're not right about that. Let me just ask you two other questions here. You focused a lot on the consent issue. You're saying this is a consensual relationship. Would you agree that we have lots of places in the law where you would appear to have factual consent, but as a matter of law, we say there's not consent?
That's what's at issue here, absolutely.
Do you think that prison guards can have consensual relationship with prison inmates?
Absolutely not. That's why it's illegal in our code.
Okay, so if you have no problem with so in other words, you just think that teachers and coaches do not exercise real-world authority over students?
No, I believe they do. Whether it rises in every case to criminal culpability, exploitation of that minor, I think is a fact question. And the factors in your bill may not necessarily get to all of the factors that we need to take into account to show that exploitation is actually occurring.
What factors are we missing?
Well, the current law...
I'm asking, I guess, in what context, for example, take Mr. Spear's case, would you say a 47-year-old track coach could have a consensual affair with a 16-year-old high school junior?
Personally, I could never, ever see agreeing to that. But if it's consensual, if the particular minor consents to it, and it wasn't...
Well, that's the premise of the whole discussion. It's just what if a prison inmate consents to the relationship with the guard? We say as a matter of law, you can't.
That's right. You override that consent under the circumstances that you believe are powerful enough to override the actual consent. And what I'm saying is, we've gone through from about a 5-factor circumstances.
I'm asking you for one factor. You're not giving me one factor that could justify a relationship between a 47-year-old and a 16-year-old high school junior.
Well, but that's right, and that's already illegal under our code, is what I'm saying. Under 3602. That particular case is already...
But I don't understand why the prosecutors are saying it's impossible to make the case and that they weren't able to make the prosecution. So,
we can follow up with that, but
okay. Would you agree then, if it were impossible to make the case under the laws that exist today, that we should amend the law to make it possible to make that prosecution?
There's no reason for that hypothetical because we have 3602. It's on the books.
Okay, if we didn't have 3602, you're saying we should have...
3602, absolutely.
We should have a law that takes care of the case that we're describing.
Sexual exploitation and sexual abuse of a minor, absolutely.
Okay, thank you for your testimony.
We don't disagree with that.
Senator Shank.
All right, I pulled 3602 here, and I think it's very material to what you just said in the answer that you gave Senator Raskin. I am not an attorney. I just play one on JPR here. But 3602, sexual abuse of a minor. Sexual abuse means an act that involves sexual molestation or exploitation of a minor. It includes incest, rape, sexual offense in any degree, sodomy, and an unnatural or perverted sex practices. I don't see how in any of those 5 categories that are listed there any of the fact patterns that Senator Raskin mentioned in his testimony would rise to that. It's simply not in that list that you're describing, because none of those are a sex offense, because the age of consent has already been reached. So how do you possibly say that 3602 is covering those circumstances?
It's a matter of case law. If you have the annotations there, if you look under sex abuse defined, sexual abuse for purposes of that section is not limited to the crimes enumerated by A42. Therefore, and furthermore, D1 notes that an act, mere act, not a crime, could establish the basis for a violation of child sex abuse. So it is a little bit confusing, but that particular provision, again, it's couched in the language of includes, which means essentially it explicates or expands the definition of sexual abuse, but is not meant to be an exclusive list. And so case law has interpreted 3602 to include acts, not necessarily crimes, including ones that are not in this particular list.
I guess the follow-up, and obviously we'll have our Attorney General review that and provide us advice and counsel, I'm certain, but I guess the more common sense approach would be, if the prosecutors aren't able to successfully prosecute any of these cases, clearly they're not finding the elements in there, so that is what to me begs the point for the bill. If they would be able to, then they'd be charging under 3602, wouldn't they?
Well, they certainly have in a number of cases. In that particular case, apparently not, and I can't explain to you why.
Okay. All right, thank you.
All right, thank you very much. Let's hear from Eileen King.
Good afternoon, Chairman Frosch, Vice Chair Gladden, and members of the committee. My name is Eileen King. I'm Executive Director of Child Justice, and we serve abused, neglected, and at-risk children and minors who are being failed by the systems that should protect them. Most of our cases are in the state of Maryland. I'm a Maryland resident myself, and I have this feeling that most people in Maryland, parents, many of them, are going to really want to hold teachers and people employed in schools to a high standard. Does that come into question? I don't think so. And I think under SB 460, people reading this would say, isn't this great that people who are part-time are going to be included in that? But what really happens in the language of this bill, and Ellen Mugman will speak more in detail about this, is that it really pulls the rug out of the teens who deserve protection. And this really happens through language where the care and custody when the minor is off campus. They don't have care and custody when the minor is off campus. Then there's also the changing of the age difference to 7 years between the teacher or other employee and the minor. So this turns our 16, 17-year-old daughters and sons into legally available sexual prey for 21 to 24-year-old teachers or employees. And the same conduct that a permanent full-time employee on campus, on school time, would be a crime if they engaged in. Off campus, off time, this would be legal. Doesn't make sense. It's not good public policy. Doesn't take much of an imagination, as I've said here, and as we know of our kids. I've had a teenager, around teenagers a lot. We all know teenagers. Yesterday we had a lot of testimony about kids using drugs, making bad decisions, kids getting into very bad situations. We want to, change the law so that former crimes can be hidden. Kids make very poor judgments and really bad mistakes. We know this. But why would we set them up to be this large, with this large age gap, to be a group that will be very easily exploited? If we look around our world these days, and you look at the families, there are so many stressed families, so many single-parent families. There's a lot of reasons for kids to be longing for connection, longing for deep relationships. They should not be seeking this from people in authority, and whether that person is from 21 to 24, that should be off base, I think. I really think it should be off base. And I want to just remind you that on August 30th last year, the Washington Post carried this op-ed by Betsy Karasik, and the title there was Unintended Consequences of Law laws addressing sex between teachers and students. She says no big deal if it's consensual. I think it's really important to distinguish people's ideas of what consensual sex is and what it really is with a person in authority. And I'm going to quote a well-known Maryland psychologist just to end up with Leon Rosenberg. He's an expert on child sexual abuse. What is being missed is the issue of a minor being seduced into a relationship beyond the adolescent's capacity to manage by an adult who is in a position of power and who requires the adolescent to keep the victimization secret to protect the adult. Based on this and, of course, much more information, we've scraped just the very top of the iceberg here. I would urge you to not give a favorable report for SB 460. Thank you.
Senator Raskin has
a question. Last point. You would like a favorable report with amendments.
I didn't say with amendments. I mean, amendments would be interesting if we could get that 7-year difference out.
You don't like the 7-year gap.
Really don't like that 7-year gap. And also, I think language has to be found that makes it a crime off-time, off-campus.
That's the only thing you're misreading. This bill does do that. This is a 24/7 bill. So you're talking about the existing law, which limits it to the direct care and custody.
Yeah, I want to be sure that there's no legality in that.
Oh, I'm with you on that.
Okay, thank you.
All right. Let's hear from Ellen Mugman.
Mr. Chairman, members of the committee, my name is Ellen Mugman, and I want to tell you that I spent a great many hours looking over this bill. It's a very convoluted bill, and looking over the statutory rape law in connection with the position of authority law, and in listening to all of this, I was confused, and I see some confusion on the part of witnesses, and with all due respect, on the part of some of the comments that were made here by senators. For example, and I want to thank Senator Raskin for putting this bill in. You mentioned last year that there was we were concerned about the 20-year-old having sex with the 16-year-old. Well, under the position of authority bill. And I want to remind everyone we already have a position of authority bill, and the position of authority bill already makes a lot of things illegal, and I think that's been lost. So it couldn't be a 20-year-old because you have to be 21. And it couldn't be an 18-year-old because an 18-year-old is not a minor. But I hope you have my testimony because I go into great detail here about what this bill would do. And indeed, it would, in essence, repeal the current position authority law in several respects. And if you closely analyze this section of the 7-year law, it can be determined that if this bill passes and would become legal, it would become legal for a full-time, permanent 21-year-old teacher to have sexual contact off campus, off time, because you're repealing part of the current law. This 21-year-old teacher would also be permitted to engage in sexual acts and vaginal intercourse with 16 and 17-year-old students off campus, off time. And this is repealing it for permanent, right now, for permanent employees, which is covered right now. That's what you're repealing with the 7 years. Not for the temporary, which isn't covered, but for the permanent full-time. Accordingly, 23 and 24-year-olds, permanent full-time teachers off campus, which are now prohibited, would be allowed under this law. So you're really, really going backwards. So you're saying, I'll give you, and I agree with you, Senator Raskin, you need to close that loophole, but we're going to make a tremendous loophole in the whole position of authority bill. And that's what I object to. And I think there's a lot of confusion about the bill. I think the bill was convoluted in many ways. And I also wanted to say that there is case law on this, and you should look at Anderson v. State in 2002, where Judge Raker writes the opinion, where she explains that 3-602 does not apply, and she tries to stretch it. And I would say that 44 states have position of authority bills in either case law or in regular law. And I should also ask you to look at 82 opinions of the Attorney General in 1997. This whole issue came to the fore in 1993. And here we are in 2014. And I would ask you really to closely study what I say in the bill, because I think I'm going to pat myself on the back that I really have done, and it's accurate, and I've checked with many other attorneys that it is correct. So I really ask you to read the testimony.
All right. Thank you very much. That concludes the hearing on Senate Bill 460.